And let's see, and we have quite a substantial number of participants who have arrived. So welcome everyone. I'm Bill Busby. I'm a fortunate member of Georgetown's wonderful environmental law faculty. And I'm also serving this year as the faculty director of our extensive environmental law and policy program. I'm fortunate to have the environmental law colleagues here with us today. We also have at Georgetown wonderful adjuncts that draw on DC's deep well of experts, 2 environmental law clinics, and also our own internationally renowned Georgetown Climate Center. We offer about 30 environmental linked courses every year, plus extensive offerings on legislation, regulation, and administrative law. It's a wonderful place. When I looked at the people who are participating, this is mostly a Georgetown audience, but we have people who have come from quite a distance away. So we welcome everyone. And we hope you'll enjoy this session. I should also start by thanking Georgetown's wonderful events and communication staff, especially Clara Kelly, Jacqueline Diaz, and Tanya Weinberg, assistant and law student Barnett Harris. And then also want to thank Sarah Colangelo, one of the speakers today. She heads our environmental law program, and she's done wonderful work to enhance our program and also help coordinate many wonderful environmental offerings such as this. So let me give you a word about our panel concept and speakers. When the election dust had kind of settled, Georgetown's environmental faculty, we had a Zoom social. It was an amazing party. We decided it would be good to offer a panel that would take stock of the repercussions of the Trump administration's 4 years and what it meant for the new Biden administration, especially given the Biden administration's more ambitious environmental agenda. The way we've structured this, we'll each offer brief remarks, leaving time at the end for Q&A. Anyone who wants to send in questions or comments should send them in via chat, and we'll screen them and get to as many as we can. To kind of shift to the speakers, I'm not going to provide lengthy bios. I want to leave time for substance, but here are the speakers in the planned order of comments. We have a great website. If you're wondering who we are, I welcome you to go look at that. The first speaker will be Sheila Foster. She's the Scott K. Ginsburg Professor of Urban Law and Policy, and also has a joint appointment at McCourt School, the Georgetown McCourt School of Public Policy. She'll focus on environmental justice challenges and the new administration. Edith Brown-Weiss, University Professor, will illuminate shifts in international environmental law policy and the new administration. Moving right along, Peter Byrne, the John Hampton Baumgartner Jr. Professor of Real Property Law, will focus on adaptation to climate change and the extent to which infrastructure investment will promote green cities. Sarah Colangelo, I mentioned her to you a moment ago, the wonderful director of our Environmental Law and Policy Program, and also coordinator of our Environmental Master's Program, will draw on her deep expertise both here, but also as a past Department of Justice lawyer. She will focus on environmental enforcement. Then Hope Babcock, the head of Georgetown's Pathbreaking Environmental Law and Justice Clinic, and also our resident natural resources law expert, will discuss policy shifts in the natural resources and public lands realm. Then I will go, and I'm going to talk about Trump's deregulatory actions, their track record, and implications for Biden's new regulatory efforts. To give it a little focus, I'll talk about battles over climate-based regulation of power plants as an illustrative and important example. Then lastly, Lisa Heinzerling will be speaking about the role of the Office of Information and Regulatory Affairs, known as OIRA, and the role of White House czars. So I look forward to hearing my fellow colleagues say, and take it away, Sheila.
Great. Thank you, Bill. And it's great to see everyone. I'm going to talk just in an outline form, hitting certain points about the administration's start on environmental and to some extent climate justice. There's so much to say about this topic that can't be covered, not in my comments and probably not even in an hour and a half, but I hope to outline what I think are areas where there can be a real break from, I think, the past, a frustrating past around the issue of environmental justice and what a challenge it has been for environmental regulators. So as many of you probably know, in 1994, President Clinton signed an executive order on environmental justice, the first executive order, which directed federal agencies, including the EPA, to ensure that their programs, policies, and activities don't result in in communities of colors and low-income communities bearing a disproportionate burden of exposure to environmental hazards. And this 1994 executive order has really been the basis for virtually all federal action on environmental justice in the last 26 years or so, including the development of an Obama-era tool for identifying which communities might be the most vulnerable to pollution. Also, there's been a environmental justice office at the Environmental Protection Agency since 1992, and there's also an Office of Civil Rights within the Environmental Protection Agency. All of these have been important areas where the issue of environmental justice has been able to be attended to, albeit with some frustration, by advocates as well as by people within the agencies. Sadly, almost 3 decades after the Clinton executive order was signed, pollution disparities have barely budged in many impacted communities. And these communities have lost faith in the federal government's ability to bring about meaningful change. And this is, I think, despite some progress made at the EPA, even when staffed by the first African-American woman, Lisa Jackson, under Obama, and many, many staff that had experience in the field. And of course, the Trump administration created further obstacles by rolling back a lot of environmental enforcement and approving oil and gas pipelines that run through indigenous land despite opposition from those communities. It also allowed a lot of dangerous pesticides to remain on the market, even though they cause harm to farm worker communities, and neglected the EPA's Office of Environmental Justice. So it's quite exciting to see the Biden administration come out from the very beginning, in his first 30 days, really, with the promise of a renewed focus on environmental justice. And I want to highlight 4 areas that I think indicate a break from the frustrating past over many administrations. The first area I'll call staffing, right? So Biden's nominee to run the EPA, Michael Regan, of course, would be the first Black man to lead the agencies. And he's also someone who grew up in, one might call, an environmental justice community, and not only brings deep expertise, but also personal experience with this. But I want to point to other top positions, actually, that the White House is filling with people who have spent their careers working on equitable climate and environmental policy. So most important, I think, is that Biden signed an executive order in late January, which, among other things, reestablishes and elevates the White House Environmental Justice Advisory Council and the White House Environmental Justice Interagency Council, both of which would report directly to the chair of the White House Council on Environmental Quality, Celia Martinez, who is now going to be in the White House, overseeing the Council on Environmental Quality, but also key progress on environmental justice. These 2 councils, right, the White House Council on Environmental Justice Interagency and also the Advisory Council, are charged with revising and strengthening Clinton's executive order in collaboration with local environmental justice leaders. They've also been tasked with developing clear performance metrics to ensure accountability in implementing the executive order, something that we really haven't had before with regard to the past executive order. So the first area is staffing. The second area is what I will call regulatory changes. One of the frustrations across past administrations has been the difficulty of fully and meaningfully incorporating environmental justice considerations into standard setting under the major environmental statutes, such as the Clean Air Act, in ways that effectively reduce the pollution exposure burden on the most impacted communities. And part of the difficulty of doing so is that these communities suffer from a confluence or accumulation of exposures coming not only from different sources, but also different exposure pathways, not just air, water, vehicle traffic, highways, but also lead in the home and contaminated soil. So strong environmental enforcement under one statute, like the Clean Air Act, or for one set of exposures, such as lead or PM 2.5, failed to really get at or illuminate the compound ways or the cumulative pollution burden in these communities. And so there were findings often that these communities were not suffering from adverse impact at all, given the narrow metrics of risk assessment. So one of the things that the executive order that Biden just signed does is that it initiates the development of an environmental justice screening tool and a climate justice screening tool that builds on actually an existing screening tool at the EPA called EJ Screen. But what this will do is build out a better tool to identify these communities and the ways that they're impacted using a much more robust set of indicators, including social indicators, or rather social vulnerability indicators that go beyond the narrow considerations that are taken into account in the standard setting process. So that's two. I think that's a significant move. Number three is enforcement. I mentioned enforcement of existing environmental laws, which has been happening, but one of the areas of under-enforcement has been the application of civil rights laws to environmental regulatory matters. I mentioned that the EPA has an Office of Civil Rights inside of it. And there's been a lot of dissatisfaction with the way that, in particular, the Title VI rules, which set a disparate impact standard, have been applied by the EPA within that office. So one of the significant things that Biden is going to do is to establish an environmental and climate justice division within the U.S. Department of Justice to complement the work of the Environmental and Natural Resources Division within the DOJ. Under the Trump administration, the EPA has referred the fewest number of criminal anti-pollution cases to the DOJ in 30 years. So not only will there be more enforcement of environmental laws, but the plan is to instruct the Attorney General to implement, to the extent possible, by executive action. For instance, Senator Booker's Environmental Justice Act of 2019 to increase enforcement, to strategically support climate litigation against polluters, and to address legacy pollution in these impacted communities, as well as to work hand in hand with the EPA's Office of Civil Rights. So the last area that I'll mention is climate. The executive order issued at the end of January gives agency and White House staff, including Gina McCarthy, the White House climate advisor, and Cecilia Martinez, the head of the Council on Environmental Quality, 20 days to formulate recommendations to meet a goal that 40% of overall benefits flow to disadvantaged communities from federal investments in clean energy, public transit, and affordable housing. This is tremendous, right? This 40% directive appears to cover spending from future legislation as well as existing federal programs. And agency heads have about 60 days to incorporate that guidance into their programs. This mandate, however, leaves open a couple of questions, like how would this be accounted for? How would it be tracked? It's not 40% of dollars. Which communities are covered under the disadvantaged communities, and how do you measure overall benefits? But nevertheless, it's a significant move, and I'll stop there.
Thank you so much, Sheila. We're trying to make sure we don't go over 10 minutes, so we have time for questions. That was right on 9 minutes. Excellent job. So thank you. And now we're going to hear from Edith Brown-Weiss. So Edie, take it away.
Thank you. It's really wonderful to be able to talk to all of you here and to be gathered with my wonderful colleagues. In the last administration, the United States stepped back from multilateral cooperation, often focused on bilateral agreements if there was agreement, and a sense of going it alone. But the problem is that the international environmental issues are ones that can only be addressed through cooperation. Climate change, protection of the ozone layer and the stratosphere, biological diversity, wastes, plastics, Arctic, etc. What the President Biden has done is to signal and take action to show that the United States takes the international issues seriously, that we are there to have international cooperation, and that we need to have a voice at the table and a seat at the table. So let's take each of these briefly. Climate change. The United States withdrew from the Paris Agreement of 2015 on climate change, effective in November. On the very first day that President Biden was inaugurated, he issued an order that made and sent a letter to the United Nations saying that the United States would immediately give notice that it was rejoining the Paris Agreement of 2015, a statement that then became effective 30 days later. He's made climate change central. Under the Paris Agreement of 2015, every country states its nationally determined contribution, which hopefully will go beyond the previous ones. The one that was adopted by President Obama was 26 to 28% below 2005 levels by 2025. And I know that President Biden is reviewing this and hopes to make a new statement regarding this in the upcoming year or two. In the year 2023, states parties to the convention will do what's called a stock take. We'll look at how far they've come with their national determined contributions in meeting the goal of limiting global climate change to 2%, to 2 degrees centigrade, and ideally to 1.5 degrees centigrade. And we're already looking potentially at 3 degrees centigrade. Secondly, the Vienna Convention on Protecting the Ozone Layer of the Stratosphere and the Montreal Protocol that controls those substances that deplete the ozone layer has a new issue before it, namely HFCs. Those are synthetic gases that are used in air coolants and in refrigerators. There are 5 amendments that have done to the Montreal Protocol, and the latest one is a Kigali Amendment, which addresses the consumption of CFCs, tries to decrease that consumption, leveling out to 85%, I believe it is, by the year 2036. Now, the United States is a party to the protocol. We had a key role in negotiating it, but we haven't yet ratified the Kigali Amendment. And the Kigali Amendment, President Biden has now said that he is sending it to the Senate for its advice and consent. That's very important because the HFCs are much more powerful than greenhouse gases than carbon dioxide. For example, they are 1 to 40 to 11,700 times more potent than carbon dioxide, and they live in the atmosphere between 1 and 260 years. So this is a very important amendment. The Russians have ratified it, and 115 countries as of today have already ratified the amendment. And President Biden has said it's time to ratify that amendment. I want to give you an image of a ship. There's a big hole in it that's getting bigger as the threat of climate change looms. And everyone may say, as the United States has done, that someone else needs to act first or do more, and eventually that ship sinks. And that's where we are now, is to try and prevent that ship from sinking. And it's very important, and President Biden has indicated that the United States will again take a leadership role on climate change. Next is biodiversity. There's rapidly rising rate of loss of biodiversity. Great increase in illegal trade in wildlife. President Biden has committed to protecting 30% of our land and oceans by the year 2030. But this is an international problem. And there are 2 aspects on which we hope that there's movement. One is that there are negotiations for a convention on marine biodiversity. Remember that oceans cover a half of the surface area of the planet, 2/3 of the area beyond national jurisdiction. And the current regimes that apply there leave gaps, and they don't account for the cumulative impacts on ecosystems. The United States has much to contribute to the negotiations and implementation of such an agreement, and much experience that we've had domestically that's there. Next, there's the illegal trade in wildlife, endangered species. There's a proposed protocol to the United Nations Convention on Transnational Crime that would focus on illegal trade in wildlife. It would join 3 other protocols against human trafficking, illegal migration, and illicit production and trade of arms. And again, this is an international issue that it's time for the United States to consider joining in. With regards to wastes, there are 2 issues here also. The first is the Basel Convention of the Transboundary Movements of Hazardous Waste, which the United States has signed. But as yet, the instrument of ratification has not yet been deposited, although I gather the U.S. Senate has given its advice and consent. There are 188 countries that are parties to that convention. It applies to hazardous wastes and the trade in hazardous wastes. There's a new amendment now on plastics of waste, which clarifies which wastes are hazardous, which are not, and are not subject to the prior informed consent regime, and addresses the issues of mixed waste. The United States at the moment relies on an agreement with the OECD, which they have not quite figured out how to work out, and a bilateral agreement with Canada, but we need a consensus and a joining of the Basel Convention on Hazardous Waste, and thus the amendment on plastics. With regards to oceans and plastics, we have the Great Pacific Garbage Patch. We haven't done anything about it. 2/3 members of the United Nations have said we may be interested in having a new agreement on that the conventions that apply are too fragmented, but we do not yet have a treaty to address the problem of this garbage patch, or really the land-based sources of waste, some of which are not hazardous and thus not covered by Basel. Turning to the Arctic. The real concern is with the melting of ice caps in the tundra and with the mining of resources on the continental shelf and the extension beyond 300 miles of national territorial jurisdiction of the continental shelf. And it's an important issue on how you determine the 350 miles or the endpoint of national jurisdiction for a state's right to mine the resources on the seabed. The Russian Federation, for example, has huge natural gas resources there. And for this, the United States needs to join the Law of the Sea Convention so that it has a voice at the table of the body, which now has, I believe, 20 members that make such determinations and recommendations to states. There's no overall international convention for the Arctic. And finally, I turn to an issue that I call protection of environmental defenders. We need to give protection for the environmentalists who are exposing acts that destroy our environment and are increasingly being murdered in a number of countries. I think the United States has a role to speak out against this and to take the lead in putting together a multinational coalition with other countries that sends a signal that there's a need to protect, not murder, environmental defenders. So my bottom line is the United States now is back in the game. It's time for us to take, and President Biden has indicated he will, an international voice on these issues. Time to always have a seat at the table and to give a voice to them. Thank you.
Wonderful. Thank you so much, Edie. And Edie also kept within the time limit. That's terrific. And I noticed, Edie, there were some questions that have been sent in, and people should feel free to send in questions. The moderators tell me best to send them in through the Q&A form, but they'll try to monitor chat if you sent a question that way as well. So turn to Peter Byrne.
Oh, good afternoon, everybody. Very nice to be with you. I wish we were together in person, but glad to be here. I teach land use law, and that's usually looking at state and local government. But I thought in this presentation today, I would spend a little time in talking about what the Biden administration may or should do regarding adaptation to climate change, and then also talk about the environmental promises of infrastructure development, which is something that has been central to Biden's campaign. So generally, climate policies are divided into mitigation and adaptation policies. Mitigation policies are those that aim to reduce the greenhouse gas emissions and to slow and eventually stop global warming. Adaptation policies are those by which communities change their physical structures or their plans in order to protect themselves in every way from the inevitable consequences of climate change, such as by elevating roads, moving rail transport, and moving people out of the way of floods and inundation or wildfires. So much of this activity occurs at the local level, but there is a real need for the federal government to both provide money and to provide a context or overall guidance so that in order to help state and local planning. This is one area where actually some good work was done during the Trump administration. In January of 2021, Trump signed the so-called STORM Act, which created a new federal revolving fund to make grants to local governments for projects to protect further against wildfires, flooding, storm surges, and other environmental ills. In general, state and local governments want money and autonomy, which is a hard thing for the federal government to agree to do. But they also need guidance. They don't always have the capacity to make judgments, and they need to understand what the arc of federal policy is so they can work within it. Biden's big executive order on January 27th said very little about climate adaptation. He did develop every federal agency to develop a plan to increase the resilience of its facilities in terms of being able to withstand climate change consequences. And he also directed agencies to expand and improve their forecast capabilities, that is to provide more data. And all of that is helpful, but it is really on the margins. It's interesting to note that so far as I can tell, that no really significant adaptation experts have been added to Gina McCarthy's staff in the White House. So it does appear that adaptation is going to be a lesser priority. And this is not surprising because not only is it something where state and local governments have taken the lead, but the politics of adaptation are pretty toxic. You don't really have the kind of established analytic metrics to determine what kind of projects give the greatest public benefit. And in that context, it's difficult to secure additional funding because it's very hard to assess whether the funding has been successful or not. And that creates all kinds of problems in the federal funding process. And ultimately, adaptation involves really hard and tragic choices about where to protect, where to let go, where to invest, and how. And that involves all kinds of dynamics of power and principle in the application of these things. And ultimately, people are going to be unhappy about it. So it's not surprising that, that federal politicians want to keep some distance from adaptation activities. So you have a situation where some people who live in areas of increased flooding are going to get multi-million-dollar buyouts from governments, and other people are going to end up shifting for themselves, and that's wrong and unfair. It is the environmental justice principles that Sheila described are urgently needed to be applied in these contexts, but it is difficult. It is difficult to operationalize that given the divisions of authority. One area where one can look for clear federal leadership in climate adaptation involves the National Flood Insurance Program administered by FEMA. This program desperately needs reform because it continues to incentivize new developments in areas that are increasingly subject to flooding and will become worse. Under Trump, FEMA completely eliminated references to sea level rise and climate change. But now it really needs to take a lead. And there are two areas perhaps that are particularly important. Namely, they have to insist that the program be based on projections about climate change that are realistic. And that the maps that FEMA uses in order to indicate where flood insurance is required be realistic and take into account both the increase in flooding and the prospect of increased flooding in the future. Other aspects that they can address within this involve issuing an executive order requiring that taxpayer-funded projects are designed to withstand increased flooding risks going forward. Moreover, and this is even more difficult, the rate setting system needs to change. There's nothing more boring than talking about insurance rates. And yet, unless the rates reflect the actual risk that people have of flooding, they're going to continue to unduly incentivize people to either build in flood-prone areas or to remain there. But this is an area where the politics have already shown to be toxic. Congress tried to undertake some reforms in the Obama years, but when the first bills went out under the increased amounts of flood insurance, it caused a revolt that caused Congress to completely back away from what they were doing. There's an urgent need that a program be done that realistically phases in these increases to appropriately price risks immediately for second homes and for new construction, but also with help for low-income people so that there's at least a period of transition. There's much more that needs to be done in terms of sea level rise, but I'm confining myself at the moment just to flood insurance. The other area I wanted to talk about briefly is the infrastructure program, because this has been central to Biden's campaign, the need to address the great infrastructure deficits that exist throughout the country. It's expected that, I should say that one of the aspects of the relief bill that's going to be passed by the House tonight involves massive amounts of money for public transportation in cities. And this is extraordinarily important for the healthy functioning of cities. All of these systems have been worn down to near insolvency during the pandemic with the loss of ridership. Many of them already had structural deficits in terms of their capital budgets. And it's just been enormously important that this bill contains substantial amounts of funds to try to make up for the losses suffered during the pandemic. Because when we go back to traveling, we need to be attracted to go on public transportation to reduce emissions. It's very important in that way. We expect to see an infrastructure bill introduced fairly soon after the relief bill is passed. And with the appointment of Pete Buttigieg as the Secretary of Transportation, someone who has a demonstrated record in green transportation and in urban smart transportation planning, we can have very substantial hopes that a bill, an infrastructure bill, which inevitably is going to contain a great deal of pork, is also going to contain some enlightened measures that are going to help to make cities places where people can live lightly on the ground and in a way that promotes community. My time is up, so I'll stop there. Look forward to your questions.
So spectacular. And I do see questions coming in. And so thankful for that. Just a technical question. Panelists, can you all see the questions coming in through the Q&A as well? Okay, so people may want to look at it, and we'll try to give each person some choice about which questions they want to address. And now we turn to Sarah Colangelo. Thank you, Sarah.
Thank you so much, Bill. Good evening, everybody, or good afternoon, depending on where you're tuning in from. It's such a pleasure to be here speaking with this distinguished panel. And my plan is to share some thoughts briefly on the characteristics of environmental enforcement under the Trump administration, and stay to my under the 10 minutes allotted. But I'd like to set the stage also as to our current status in enforcement, and then highlight the likely upcoming changes with respect to President Biden's EPA and DOJ enforcement priorities and policies. And I'll note at the outset, I think Sheila highlighted already some really important observations as to the growing and imperative link between enforcement and environmental justice. So you've heard already some of the damage that the Trump administration wrought to our nation's environmental systems. And the outcome was no different in the environmental enforcement context. The Trump administration's policies and substantive practices related to enforcement all contributed to a low point in federal enforcement, as demonstrated across multiple metrics representing various phases of the enforcement process. So to take just a few examples, inspections were down, at least to a 10-year low in inspections of facilities, and that's our way of ensuring compliance or identifying potential violations. Referrals from EPA to DOJ were also down. Litigation referrals are the mechanism by which EPA officially submits a case to DOJ for resolution. Typically, these are matters necessitating more complex injunctive relief and higher penalties or criminal prosecution. Now, enforcement statistics have been declining slowly since the 1990s, but the drop-off was nonetheless precipitous in the Trump administration. And at one point, as Sheila highlighted, criminal referrals plunged to a 30-year low, and civil enforcement did not fare much better than that compared to the Obama administration and the Bush administration. And further, throughout the Trump tenure, the amount of civil penalties collected and the value of injunctive relief secured were also significantly lower than the past two administrations. And of course, the agency also lost talented employees to budget cuts, early retirements, and just plain low morale. And as I just read that right now, maybe your morale is going low too. But overall, there were some notable settlements. In particular, I think those focusing on motor vehicle manufacturers that evaded mobile source emissions. But on the whole, again, we really saw a very significant decline in enforcement under Trump. And part of the decline was due to enforcement policies, which reflected a singularly circumscribed approach to environmental enforcement. For example, the Trump administration adopted a much narrower stance than any recent administration on enforcement tools that can remedy the impacts of illicit pollution at the location in which the violations occur or within the same airshed or watershed. These tools are called mitigation and supplemental environmental projects. Some of them have been in the news recently, and I'd be happy to speak more if there are questions or interest in those particular enforcement tools. But now we're a few weeks into the Biden administration, and we're seeing signs already of a very significant shift in environmental enforcement. A few actions relevant to enforcement have happened in very short order. First, as Sheila mentioned, President Biden's January 27th, 2021 executive order crystallized his consistent signaling that climate and environmental justice will be top priorities. And the order creates several directives for EPA and DOJ that are relevant to enforcement, and I think bear highlighting here. First, an order to strengthen enforcement of environmental violations with disproportionate impacts on underserved communities, and in order to develop a comprehensive environmental justice enforcement strategy, specifically to provide timely remedies for systemic environmental violations. Interestingly, the order also includes a directive for the Attorney General to consider renaming the division to the Environmental Justice and Natural Resources Division. And for anyone who's surprised by that, for what it's worth, the division has changed its name roughly every 20 to 30 years in its history, often reflecting the broader legal focus of a certain era. And it became the Environment and Natural Resources Division in 1990. So we might be ripe for a change. And as Sheila mentioned, the executive order also suggested the creation of a new Office of Environmental Justice within the division. And we're going to see how this new office is staffed and organized, and we'll have to watch from there how it strengthens enforcement initiatives linked to environmental justice. Also of note, on February 4th, 2021, the acting head of the Environment Division, career attorney Gene Williams, rescinded several of the enforcement policies I mentioned earlier, such as those curtailing or prohibiting the use of supplemental environmental projects and mitigation. On the ground, I think that this is going to immediately provide ENRD and EPA more options to comply with President Biden's order on developing an environmental justice enforcement strategy, because as I mentioned earlier, these tools can be used to secure cleanup or offsets of unauthorized pollution where the violations are happening, and often that's in these marginalized communities. So I think we're meeting this moment, if you're in the enforcement world, you're meeting this moment with excitement and enthusiasm, but it's tempered. We have to grapple with some sobering realities that environmental enforcement is underfunded, with an unknown level of compliance for a significant proportion of regulatory programs, and it's been uneven. There remains a persistent disproportionate distribution of environmental harms on marginalized communities, where there is under-enforcement of environmental regulations among a host of other contributing factors to a degraded ambient environment. So I want to spend the remainder of my time prognosticating a bit about what we might anticipate from environmental enforcement from a substantive and procedural perspective. First, a reminder that environmental enforcement is more like a spigot than a switch. Its machinery requires time and sequencing to return to full capacity. So when I talk to people, including my own students, I urge a little bit of patience, but enthusiasm is good. That said, I think we're going to see an attempt to reboot the machinery and then expand its efficacy. And by that, I mean, I think we're going to see a quick pivot, as quick as possible at least, back to the Obama era efforts, and then a very concerted effort to go beyond them, in particular in those areas, again, that will curb greenhouse gas emissions and matters that address illicit pollution harming marginalized populations, communities of color, low-income communities, and rural communities. So for example, these priorities almost certainly guarantee a renewed focus on coal-fired power plants, petroleum refineries, oil and gas wells, and vehicle emissions, because controlling illegal pollution from these sectors is going to serve all those goals. Other regulatory programs might also receive significant attention. One program that I'll be watching for is the chemical accident prevention regulations. They were strengthened under Obama, attempted to be strengthened, and then rolled back under Trump. And these are regulations under the Clean Air Act that are designed to prevent a Bhopal-like disaster. And they're instrumental in protecting workers and frontline communities from things like chemical plant explosions. Or perhaps we might see a focus on bringing smaller municipal sewer systems into compliance, a forced revamping of infrastructure serving rural minority communities. And I will say the EPA and DOJ did a fabulous job over the last 2 decades, slogging it out major city by major city, trying to get our sewer systems into compliance with the Clean Water Act. But I do think rural communities are making compelling arguments that their systems have been left behind. So finally, I also think you're going to see the nature of environmental negotiations, or at least I hope we'll see this, nature of environmental negotiations evolve to better incorporate and more broadly incorporate participation by community groups, or at least an effort to understand and a focus on understanding how violations of law affect communities on the ground. And my thought is that that will really ultimately lead to incorporation of better remedies into agreements or judicial orders. I'm also more broadly interested in seeing whether that might lead to a larger repolarization of the relationship between DOJ and EPA concerning enforcement. Broadly speaking, how can we revamp our traditional metrics of environmental enforcement success to incorporate the need for community engagement? I think that remains to be seen, and I think it's probably largely dependent on resources rather than enthusiasm from those at the division and EPA for this particular effort. But those are just some, ending with some broad thoughts. Thank you so much.
Excellent. Everyone's so punctual. That's terrific. And again, I see questions coming in. Thank you for those with questions. We'll hope to figure out the best ones we can get to get to some questions that will link things together. So now we turn to Hope Babcock. Hope.
Thank you, Bill. Welcome, everyone. It's a pleasure to be here, and thank you for providing an excuse so I could listen to my colleagues talk about what they've been working on and what they hope will be coming up. I've been charged with looking at some of Biden's public lands initiatives since taking office, and naturally that means taking a look at what the prior administration did, but not exclusively. So let me start with President Biden's moratorium on new federal oil and gas leases on public lands and the Outer Continental Shelf. Now, the purpose of the moratorium is to enable a rigorous review of existing leasing and permitting practices, but note that it does not apply to existing leases or drilling activities on state or tribal lands. In the short term, the moratorium is expected to have a minimum impact on industry because industry has stockpiled permits in anticipation of the ban coming down. So there are 10,000 permits which can continue to be used, plus more than 13 million undeveloped leased acres not currently being used for production. But the ban's long-term impact could be significant, as it could lead to a reduction in our domestic oil supplies. It will hit smaller producers hard who have not been able to stockpile permits, as well as operators in the Permian Basin in Texas and Outer Continental Shelf producers in the Gulf of Mexico. Once the existing supply of permits is exhausted, and this is anticipated to happen in 3 to 5 years, the country could lose up to 300,000 barrels of petroleum production per day. The moratorium also provides incentives for the oil and gas industry to invest in renewable energy production and technology. It sets a concrete goal of doubling wind energy production in the Gulf by 2030. And the order additionally tasks the Department of Interior to review the permitting processes on federal lands to make them more amenable to renewable energy projects. So there's a push to move to renewable energy. Needless to say, the moratorium is a bit controversial. Lawsuits have been filed. Republican attorney generals from 6 states wrote a letter to Biden warning him not to overstep his authority. Additionally, Republican senators and members of Congress have introduced legislation to block the moratorium from going into effect. And 25 Republican senators have introduced a bill to require congressional approval of any effort to suspend oil and gas leasing on federal lands and waters. However, given the fact that we have a democratically controlled Congress, one is not expecting to see these bills advance much. Second, Biden has directed federal agencies to eliminate fossil fuel subsidies by 2022 and to identify new opportunities to spur innovation, commercialization, and deployment of clean technologies and infrastructure. Currently, the federal government funnels nearly $15 billion a year to oil, coal, and gas companies in tax breaks and subsidies. The states give same industries $5 billion a year. It's going to be really hard, I think, to realize this order, especially as it calls for federal tax cuts, elimination of federal tax breaks, and Congress is going to have to approve any initiative like that. It's also going to take time to sort out which subsidies should be cut and to determine the effect of the cut on consumers. There's a lot of work ahead to implement that initiative. Biden has set a 30 by 30 conservation target on public lands, and I think it's already been mentioned. The goal is to protect 30% of the nation's lands and oceans by 2030. Ambitious goal, but doable. More importantly, it's going to provide a focus for conservation acquisition programs and planning. Criteria will need to be developed to be sure that high value lands and waters are indeed going to be protected. Compared to the moratorium, not surprisingly, this initiative is quite popular. More than 400 state and local officials from 43 states have signed a letter to Biden pledging to help achieve the target. The initiative also pledges to establish a process for engaging with a broad range of stakeholders, including tribes, farmers, anglers, states, in implementing the order. Noticeably absent, and I read it several times, seem to be the hunters and the gun industry. Yet another executive order lists some of Trump's endangered species and wildlife initiatives that he issued during the last year of his presidency, which Biden has said he's going to review. Some examples of these actions under review are Trump's removal of language in the listing rules of the Endangered Species Act, prohibiting any reference to possible economic or other impacts on the listing criteria. Critical habitat, changes to the definition of adverse modification of critical habitat and the definition of critical habitat. Making mandatory the Fish and Wildlife decision to delist species as opposed to it being a discretionary duty, and allowing species delisting without rigorous proof of extinction or recovery. His rescission of the automatic extension of the protective take prohibitions to newly listed or reclassified and threatened species, which under Trump, would have received full ESA protection from illegal takes. Only, so he's narrowed that protection down to only if the Fish and Wildlife Service promulgates a species-specific rule extending the protection. So he's narrowed a very important protection in the Endangered Species Act way down. Trump's expansion of the circumstances in which designation of critical habitat can be found to be imprudent and therefore not need to be designated, and allowing for incremental degradation of critical habitat, provided that the habitat as a whole maintains its conservation values. Trump has changed the circumstances in which a federal agency action could jeopardize the continued existence of a species and thus be disallowed, making it less likely that those circumstances would arise. Trump effectively permitted the service to disregard the controllable effects of agency action that harm species because agency action is not the sole cause of the threat. So the illegal take provisions of the Endangered Species Act, which are critical to protecting species, Trump had narrowed way down. Taken together, these revisions to the rules implementing the Endangered Species Act, sections 4 and 7, made it easier for the Fish and Wildlife Service and the National Marine Fisheries Service to delist endangered species, removed automatic protections for newly listed threatened species, and altered the amount of land considered critical habitat. Biden is reviewing all of those initiatives. And interestingly, a suit was filed by the environmental conservation community in the Northern District of California, challenging these rules, and the court is also reviewing these changes. Also under review are Trump's decision to overturn Obama's ban on using lead ammunition and fishing tackle on federal lands, the ban on hunting predators and Alaskan wildlife refuges, and the ban on using bait, lure, and kill grizzly bears in some national wildlife refuges in Alaska. And Biden is additionally reviewing several species-specific initiatives by Trump. For example, Trump decided to shrink northern spotted owl critical habitat by more than 3 million acres in Washington, Oregon, and Northern California. His rescission of a warranted but precluded finding on the monarch butterfly, which is close to being on its last wings, and not warranted findings on 11 other species. His rescission of BLM's, the Bureau of Land Management's Greater Sage Grouse Resource Management Plan, and the delisting of the gray wolf. I don't know if those of you who are wolf aficionados, but states where the wolf is prevalent and had been protected once the protections were listed have already authorized hunts, and the results have been absolutely horrific. Wisconsin just did one, and they meant to run the hunt for several weeks. 3 days, the quota was filled, and they had to end the hunt. Biden is reviewing Trump's issuance of regulations and policies arising from his administration's position that the unintended take of migratory birds is not prohibited by the Migratory Bird Treaty Act, and a related 2017 Department of Interior solicit opinion. Yesterday, the Biden administration rescinded the solicitor's opinion and announced it will issue a proposed rule revoking the corresponding Trump administration rule. Biden got a 90-day stay of lawsuits challenging Trump's removal of more than 2 million acres from Utah National Monument sites, that's Bears Ears and Grand Staircase Escalante, while he reviews whether those protections should be restored to those lands. Western Republican lawmakers, needless to say, are very upset at the direction of the review. Biden has proposed, and this one I really think is neat, and I wish more people focus on it. Biden has proposed to reboot the Depression-era Federal Civilian Conservation Corps to conserve and restore public lands and waters by increasing reforestation efforts and by increasing carbon sequestration on agricultural lands, as well as improving access to recreation. Wetlands. Biden has rescinded Trump's restricted definition of navigable waters, which is the basis of regulation of wetlands. That is a very controversial regulation. a new rule will have to be issued, changing back the definition, and I expect that that's going to, as I say, be highly controversial. So let me quickly, Bill, if I
hope that's actually about 10 minutes. So if you want to wrap up, that would be.
I do. I'm going to wrap up just by saying that Biden has rolled back a lot of nasty things that Trump did with respect to NEPA, the National Environmental Policy Act. So let me end there. Thank you.
Okay, I think it falls to me now. So thank you, Hope. And actually the perfect transition. Hope there at the end was describing a lot of the areas of promulgated notice of comment regulations by the Trump administration that weakened regulation, and then the repercussions for Biden. And that's what I'm focusing on. So first, Trump's overall deregulatory record. It was overwhelmingly deregulatory, very few areas of any enhancement of protections, but a remarkably low level of success in the courts. Usually agencies win about 70% of the time. The Trump administration loss record at various points was between 70 and 90% losing. So a complete flip from the usual administration favoring outcomes. But this does not mean that judicial losses, this does not mean that the Trump deregulation was ineffective. Lousy deregulation can provide a period of deregulatory relief. And so many industries were thrilled to have this period of no new actions and in fact weakenings. And also deregulation can be a political win. So this may also have enhanced some of the political prospects for President Trump and his allies. Now, there were kind of two waves of Trump deregulation. The first wave was a slew of actions that were stay and delay actions, where agencies just tried to basically say, these regs won't go into effect. This violated the Administrative Procedure Act and pretty long-standing law that it takes a notice and comment rule to undo a notice and comment rule. And similarly, to undo a rule, an agency has to provide good reasons, leave no unexplained inconsistency, look at the facts on the ground, analyze reliance interest, basically do a comparison of the old and the new. The Trump administration did not do this and was roundly rejected in courts, I think virtually always, because so many of these actions had this flaw. So the result is a sound body of law that built on preceding law, but it's also a clear body of law that will be constraining the new Biden administration. So it's kind of clearer what they have to do, but it's also clear it's a lot of work to change regulations. The second wave of Trump deregulation was a bit more careful, but had two prevalent, vulnerable, I think, legal flaws. One is their agencies again and again use what I've called statutory abnegation claims. The agencies claimed that they never had the power they had previously claimed and asserted, and then would propose new deregulatory actions that were avoiding this newly found lack of power. And this is very different from normally how agencies normally work. Normally agencies, new administrations, a voice just spoke, want to make sure, okay, everything's okay. Normally agencies, when they offer new policy, will say, we see a better way to do something. And so they adjust policy, but without a dramatic new legal claim. The Trump administration had this different approach, claiming what was done in the past was simply illegal and could not be done. The second element was in regulation after regulation in environmental and other areas, the agencies did a very shoddy job with science, facts, and effects analysis. They really didn't even try to do the comparative analysis of effects and reliance interests that Supreme Court precedent has long required. So there too, they've met with many rejections, but they weren't quite as one-sided. So to kind of put some meat on the bones of this description, let me just turn to the ACE rule. This is the Affordable Clean Energy Rule. Now, this was the Trump replacement of the Obama Clean Power Plan, and it too suffered from these flaws that I've mentioned. So first, both Obama and Trump's regulations, the goal was to regulate greenhouse gas emissions from existing coal-burning power plants. And so it's an important body of regulation for climate change, but also an important illustration of Trump deregulatory pitfalls. The Obama administration did this massive empirical study of the power sector, what states were doing and what businesses were doing. and designed the Clean Power Plan to look at what was the best being done out in the states and among coal-burning power plants. This included allowing what's called generation shifting, shifts away from one mode of generating power to another, and also things like trading of pollution. The phrase coined about this was regulation outside the fence line. The Obama EPA said this makes sense. The statute allows it when you look at the language of best system of emission reduction. And similarly, they said the interconnected nature of the grid makes this logical and actually very cost effective. The Trump administration, so I should say the Obama regulation never was ruled on in a dispositive way. The DC Circuit heard argument, but never had a ruling. The Supreme Court stayed the effective date of the Clean Power Plan, but issued no explanation. And Lisa Heinzling here wrote a wonderful article about that strange stay ruling. The Trump administration blundered in their first efforts to undo the Clean Power Plan, but they eventually generated the ACE rule as a replacement. This was dramatically different. It focused completely on each plant by itself, and it also prohibited states or power plants from complying by using cost-effective generation shifting or pollution trading, basically precluded anyone looking outside the fence line. This regulation also, the Trump regulation, extended deadlines for compliance with its new requirements. And as a result, it meant it was inflexible, costly, and very unambitious. And as a kicker, it was slow to take effect. EPA relied in substantial part on an abnegation claim, saying it never had the power previously claimed and that it had to regulate inside the fence line. And there was very skimpy empirical data. The DC Circuit at the end of January ruled and rejected the ACE rule. And it highlighted the points that I just highlighted here. So first, it said, the court said that the Trump EPA erred, saying it could only consider measures at the source. The DC Circuit said nothing in the statute so requires. The DC Circuit pointed out that the Trump administration had engaged in some clever manipulative word insertion, you leg and reg students. Trump EPA claimed the regulation had to be at the source, but the statute actually doesn't talk about technological, it talks about a system, and it calls for analysis of the best system for controlling pollution. And the DC Circuit said that could include generation shifting. The statute lacks the straitjacket. Similarly, the court faulted EPA for its wooden refusal to factor in reality and also failure to analyze the environmental effects of the big extensions on compliance. So where this leaves things, let's see, down to, okay. Where this leaves things is the Biden administration starts with a cleaner slate. The ACE rule was declared illegal. It is not in effect. And this ruling also clarified the DC Circuit's view of EPA's discretionary power. EPA under standard law can consider the issue afresh. Now, the Clean Power Plan is now way out of date, and it never went into effect. And the Supreme Court never explained why it stayed that earlier regulation. So EPA really has to decide anew, how should it regulate greenhouse gas emissions from power plants? What it clearly must do is it has to do this comparative analysis that the law requires. It has to update all data. It has to confront its own different claims about power. And it also has to look at any reliance interests that may have developed with various regulatory changes over the past two administrations. But on the other hand, the Biden administration does have the DC Circuit making clear the discretionary policymaking space that it has. So what do you have? 4 years of break from the Trump administration, but the legally flawed deregulatory effort left basically nothing other than this 4-year delay. And so now the Biden administration can move forward. And I think that's what we'll be seeing now. So let me stop there and I'll turn it to Lisa Heinzerling. You're muted now, Lisa.
Every single time I do that. Anyway, hello, everybody. Great to see my colleagues and great to know that so many of you are at the listening to this evening's talks. President Biden obviously has made climate change one of the priority issues of his presidency. He's already laid important groundwork for ambitious action on this problem. He's appointed fabulous people to positions in agencies. Ignore the beagle barking in the background. He's issued sweeping executive orders to undo the damage done by the Trump administration, as we've heard about already, and to pursue an affirmative agenda on climate. So the administration shows every sign of wanting to make good on its climate pledges, and I'm very happy about that. But every single bit of environmental progress in this country comes hard, and ambitious action takes steely resolve. The administration must not make it easy to say no to strong action on climate change. In that regard, I have two worries about the administration's path forward, or really actually one worry and one observation. The worry has to do with the proliferation of personnel who are empowered to play a role in shaping the policies that agencies develop on climate change. To put it simply, who will run the EPA in this administration, and the Departments of the Interior and Energy and Agriculture? Will it be the heads of those agencies who are charged with this task by Congress? Or will it be President Biden's aides in the White House? And among these aides, who actually will run the show? The National Climate Advisor, the Special Presidential Envoy for Climate, the Special Assistant to the President for Climate Policy, the head of the Council on Environmental Quality, the Director of the National Economic Council, or the Director of the National Security Council? Or will it be the yet to be named Administrator of the Office of Information and Regulatory Affairs? I have my own old-fashioned idea that the person who should run these agencies is the person charged by Congress with doing this, the person instructed to implement the laws Congress has passed. That would be the head of the EPA, for example, would be the head of the EPA. But if that isn't to be the case, then we at least should know who in the White House is in charge of climate policy. We need clear lines of authority. When there are a lot of bosses, it's easier to get a no than to get a yes for any particular advancement in environmental policy. So far as I can tell, we do not know who will run the environmental program of this administration. What will be the relationship, for example, between the climate czar and the head of the Office of Information and Regulatory Affairs? For now, until we know, I simply worry about what the effect of the complicated multi-person structure that the president has created with all good intentions, what that'll mean for regulatory policy once things really get moving. Second, I have an observation. The operation of formal cost-benefit analysis threatens the very policy priorities the Biden administration holds most dear. Presidents since Ronald Reagan, as you may know, have insisted on evaluating agencies' major rules by subjecting them to quantitative cost-benefit analysis. This is an analysis that aims to quantify and to monetize the costs and the benefits of major policy choices. This mode of analysis is terrible for decisions that have consequences in the far future and for decisions that touch on fairness and the distribution of resources. With respect to climate, cost-benefit analysis insists on discounting future benefits. And in the case of climate, this happens over the course of centuries. Discounting operates like compound interest, but in reverse. So instead of magically making money grow into the future, it magically makes future benefits of strong action on climate change disappear. In addition, cost-benefit analysis has never figured out how to fit considerations of fairness and the distribution of resources into its equations. In this light, a memorandum issued by President Biden in January entitled Modernizing Regulatory Review, doesn't sound so interesting, but it is. That memo may be critical to the success of the administration's climate agenda. The memorandum asks for recommendations to improve the White House process for reviewing regulations. It specifically highlights the values of racial justice, environmental stewardship, human dignity, equity, and the interests of future generations, and asks for suggestions about how we might finally absorbed these values into the process of regulatory review by the White House. These are the values threatened if the Biden administration insists on running its rules through the cost-benefit sieve. Thus, the success of the effort to remake regulatory review, I think, will help to determine the success of President Biden's climate agenda, although that connection may not be obvious to everybody. Thanks.
Wonderful. So thanks so much to all the colleagues, and thanks also to the participants for a slew of great questions, trying to distill them and seeing us down to our last few minutes. I'm going to take the prerogative of the chair and try to distill a few down to some issues that may be cut across several of the panels. So one question to Sheila, but maybe Sarah as well, is really wondering, could we see more, like, kind of how much can Title VI really be enforced with greater zeal going forward? And so that was a question, just wondering, in other words, is there a substantial legal change that we could see afoot, or is just attitudinal? What do you think?
Yeah, I think that's a really great question. I mean, so there are two, I think, areas or places where it can be better enforced. One is within the EPA, right? The EPA set up a whole Title VI guidance process that then a lot of environmental justice advocates were very upset that basically the civil rights disparate impact, adverse impact framework fell out of that when it was enforced. So the questioner referred to a decision called the Select Steel decision. And basically, that's just a matter of how you apply a civil rights framework onto environmental regulation. The history of this has been, it's a very uncomfortable fit. You could also, at the DOJ, and I've worked with the Environment and Natural Resources Division to issue new guidance under Title VI about how to enforce those regulations at places like the EPA. You could issue new guidance. And so the new enforcement arm of the DOJ that is focused on environmental justice might take that up. So that's one place where you might see some forward movement. I doubt you'll see it at the EPA, actually. Sarah?
Yeah, I echo what Sheila said. And actually, what first came to my mind was new guidance coming out of whatever shape this new environmental justice office takes at DOJ. That's where I think that's where we would see it first.
Okay. One other question that was raised, and some were put in the chat, and I kept track of them, and some were put in the Q&A. And this is one that's probably mostly for Edie, but someone raised a question about the problem of climate-induced migration of people, and just wondering if there are effective ways to deal with this. And I was wondering if you had any thoughts about this, whether people are thinking about the problem of climate-induced migration of people and its repercussions.
I think this is a very, very important issue. The convention we have on refugees really doesn't get us where we want to go at all. I don't have a solution, but I do think we need to address it not only in the think tanks, but with an international efforts to see how we might move on climate migration.
Okay. And then there's a question. Go ahead, Hope. You're muted, Hope, but go ahead, unmute. Hold on, Hope, you're still muted.
Tribes. Okay, nobody has mentioned tribes yet. Okay. Tribes are critically important with respect to what's going to happen to them, because a lot of them occupy their lands, their reservations are in coastal areas or near water, and we all know what's going to happen. So one needs to think specially about how tribes can migrate from where they are to where they need to be, where they are going to disrupt existing patterns of, where people are living, what's going to happen to their lands, which are ceremonially important to them, what's going to happen to the graves of their ancestors. We're going to pick them up and move them. So there are lots and lots of questions, just looking domestically of what the impact of climate change is going to be on tribes. And with respect to migration of species, they're also moving. And it's going to be important that we protect corridors for species to be able to migrate from where they are to where they need to go in order to survive. So thank you for letting me address those topics.
Thank you. And then Peter, there was a question that I thought was an interesting question talking about climate creating or exacerbating the already existing problem of urban heat islands, which I have friends who work in the public health arena have mentioned this as really a potentially grave risk in urban areas where extraordinary heat events can be killers. Just wondering if you had any thoughts on that question.
Well, there's an obvious need to address that with foresting urban areas, adding more green space, more recreational space. And a number of cities are acting on that. Washington itself is planting a lot of trees. There's a big issue about the provision of trees and green space in minority communities that have been shunted into less desirable areas and don't have access to green space. I think that's something that we're going to see a lot of effort on over the next number of years.
Okay, and I have a question. This is a question that was partly probably for Peter, but Lisa might really logically go to you in part, which is you identified substantial risks of the proliferation of White House personnel and uncertain lines in the leadership front. And one of the questions submitted earlier, I think it was on the chat right before you arrived, was asking about the Green New Deal and infrastructure projects. And that being an area where you have obviously dozens, if not hundreds of agencies that might be involved. Could there be a benefit if the Green New Deal and infrastructure get linked? Might there be a benefit to having powerful people in the White House who would steer multi-agency efforts in a way that otherwise they might founder?
Yeah, I've long thought that White House involvement with agencies' decisions can be justified when there are significant interagency dimensions, when there are agencies that'll otherwise not play nicely together and not get their act together, not coordinate and so forth. I think the White House has a perfectly acceptable role to play there, and I think it can be a productive role. The role that I had in mind was more the way that has been for 40 years a way to say no to ambitious regulatory programs. And that's the process of review of agency rules. So I think there's a real substantial role for the White House. I just don't like it playing the role that has it being the gatekeeper that's always saying no or weakening regulations.
Okay. I just tried to distill a bunch of questions down because we were a little over time. Do any of the panelists want to make any final comments or respond to any questions that you found particularly interesting that you'd like to address? Well,
I would just say we're at the beginning of a long road, and it shouldn't be surprising if after the big flurry of executive orders at the beginning, splashy announcements and so forth, the agencies go to ground for a little bit. They have a ton of work to do. It's really hard work. And so I actually hope not to hear about any more executive orders or any more orders for a while, because they have a lot on their plates, and we should probably let them do their work.
Yeah.
I will also.
The only thing I had just to pick up on that, I think the Obama administration, the strength of its regulatory actions was it did a very careful work in all of its regulations of documenting effects, risks, business practices. And that was part of the reason Trump deregulation didn't do very well. And so I think the Biden administration will need to learn from Trump defects and Obama strengths, which is it's hard work, and this is definitely not White House work. This is agencies doing the legwork to figure out particular problems and particular methods. So I agree with Lisa. I think this is going to be something we're going to be seeing over the coming years, agencies having to do very diligent, hard work. Someone else was going to say something and I stopped.
I just wanted to jump in. I saw a question posed about what a law student or prospective law student can do. I don't want to open that up because I think everyone on this panel has ideas about that. And in fact, that idea is an inspiration. I think I speak for everyone here and part of why we do what we do, which is to help propel law students towards their best potential in contributing advocacy and environmental causes. So I just wanted to say to whoever asked the question or anyone else who has questions, please do feel free to email me. If you look up environmental law at Georgetown, I show up just because I'm the program director. So you can find my email very easily, and I can direct comments to whoever is the particular subject matter expert or address anything you want to know. But it's a great question, and we're all very enthused to help you get involved.
And I will also just say that, you know, we could have a whole other panel on the role of state and local governments on some of these issues, particularly on climate adaptation and climate issues. So if you are a law student interested in this area, just know that the federal government and federal agencies are not the only place where a lot of this happens. I've been sitting on a mayor's panel for climate change in New York City for the past few years, and there's a lot of work being done at that level on adaptation, for instance, and in green infrastructure.
Yeah, one of the questions was, how can we move fast enough? And I just want to point out that we've been discussing the laws and regulations, but really we need to involve the private sector. They have a very key role. We need to involve local communities, cities, and states, which have taken a leadership role here. And we need to involve the financial sector. And I think the increasing involvement of the financial sector, the European Central Bank, and other banks, and Securities and Exchange Commission, et cetera, that's going to be critical to how we solve this. And my final comment is, this is really a bipartisan issue, protection of the environment. And if you look over the last 50 years, both Republicans and Democrats have taken leadership roles internationally in trying to address these issues. And so this is, if we're going to protect the climate, it really has to be and should be a bipartisan issue.
And it's hard to follow up on that comment, but don't forget Congress. There's a question from a former student of mine. How do we make these protections of wolves permanent? Because it's going to change from administration to administration. Congress is the only one who can make something permanent other than a court arguably stopping something bad. So put Congress on your list of things to be concerned about and to work with.
I'd like to mention, just for students, in picking up on the comments about the importance of state and local government, that the Georgetown Climate Center, which is here at the law school, is the leading think tank in the country in coordinating leadership states in developing and sharing pro-climate policies. And it's a great opportunity for students to working through them in their practicum and as RAs to get involved in really the work right on the ground.
Yeah, and the one thing I'd say to add to several of those comments, or maybe try to link them, is Congress is critical, given the gridlock, I think, and the need for state and local buy-in. We're going to see a lot of use of conditional federal spending in other Green New Deal type things, infrastructure bills that try to elicit and solicit involvement of state and local governments and businesses. And I think that's just how they're going to get people to the table. So probably less standard setting and more kind of trying to draw people in to participate. And so I think that's just something we'll see a lot more. For those 1L students who are studying con law and you encounter conditional federal spending, watch it. That's where there'll be a lot of the action will be on that front. I think we are out of time. Any final words? Well, thank you very much for everyone who joined us tonight. Excellent questions and wonderful participation. And thank you to my colleagues for their insightful remarks. And everyone stay healthy.
Peace.